So hello and welcome everyone. Today we are going to take a look at a decision from the UK in the Optis Apple case. And this is a particularly interesting decision because it actually does a front determination. So the court, here in our case, the Court of Appeal, determined the terms for a global license on front terms for Optis's portfolio. This is even more interesting because this was a decision of the second instance. So the court here basically took a look at the respective exercise that the High Court, the first instance court, had undertaken before and provided some input. And I can already have a bit of a spoiler here. It criticized the first instance rate determination in several aspects. So we're going to take a look at that. This is the focus of the decision, really focusing on the rates, on the determination of the rates, the proper rates for a global front license. But apart from that, there are also some interesting remarks of the court regarding the question of how to treat parallel proceedings in multiple jurisdictions when it comes to the rate determination and how to observe and respect the jurisdiction of other courts that might be handling the same case in parallel. So these are the topics. And as we always do, let's take a quick look at the story behind the case here. This case has already been there for a while. The first discussion started already back in 2017 between Optis and Apple. So we are already in year 8 after the discussion started. The litigation started in February 2019. Optis filed lawsuits against Apple both in the UK and the US in parallel. In the US, the proceedings focused on 5 patents, US patents, and damages was the main topic there. In the UK, the proceedings included also a claim for injunctive relief and also a claim of Optis to have a global front determination. Now the proceedings started and went on in parallel. As it was common at that time in the UK, the court started with technical trials, meaning looking at the infringement and the validity of the patents that Optis had asserted in the UK, and then turned to the issue of a front injunction, whether an injunction was to be granted or not here, and then turned to the issue of the actual front determination, so determine the actual front terms and conditions here. Interestingly, the first final decision, or the decision that at least concluded the proceedings in first instance, was delivered in the US. In September 2021, the US court awarded Optis $300 million for the infringement of 5 US patents. At that time, the UK court had not made its front determination yet. So the proceedings there were in the phase where the court still discussed whether an injunction should be granted or not. And this was interesting, however, nevertheless, because in almost simultaneously, the High Court had delivered its ruling and found that there should be a front injunction in this case here, which means that an injunction would be enforced unless Apple would commit to take a license on the terms that the UK courts would determine, which Apple refused to do until that point in time. Now, after this judgment was delivered, Apple committed to take the UK court-determined license, however, appealed the proceedings. And just keep that in mind, because this track is also interesting. It was mentioned by the Court of Appeal regarding one specific question, which we're going to see later on. So although there was the commitment, Apple still fought against this, this obligation basically to accept the terms of a UK court-determined license. And also when it lost in the appeal, it filed an appeal before the Supreme Court regarding this question, which was withdrawn at the end only in September 2023. So just for us here to keep in mind, until September 2023, there was still not clear that Apple would commit to accept the terms of the court determined license in the UK. Now, after this was then clear, then we had also the decision of the UK court regarding the front determination. This the judgment was delivered in May 2023. And the decision was appealed. But before that, and this is something also interesting, after this first instance decision of the High Court regarding the front determination, there were further hearings in the court in the UK and submissions of the parties regarding especially the non-royalty license term of the license that the parties should sign. Because what the court had done when it made this front determination was to speak about the fundamental terms. So it was about the scope. It was about, we're going to see that in a moment in more detail, about also the rates. But there were also some other terms, of course, that are needed for a license. And there was a follow-up discussion before the court between the parties regarding exactly these terms. Now, during these discussions, the parties more or less agreed to most of the non-royalty related terms. But then when the next order, the follow-up order of the High Court came, and this was in February 2024, the High Court did not include most of the terms that the parties had agreed, but added some terms that the parties had not discussed. And as we're going to see in a moment, it had also some provisions regarding the US proceedings in parallel and how to treat them, which had been problematic and concerning, and were also part of the proceedings here in the appeal. Now, this decision again was appealed, so the Court of Appeal had to deal with the rate determination of the first instance court and all of the other issues, including, for example, interest payments and also the relation with the US proceedings in the case we're discussing here. And it did so with this decision of the 1st of May 2025. So this was the decision the latest decision from the UK in this case. This will most likely continue to the Supreme Court. And apart from that, we had also an interesting development shortly after this decision was delivered, because also in the US, the appeal against the first instance damage award, was delivered. And here the US Court of Appeals for the Federal Circuit ordered a retrial regarding the $300 million damages award. So to sum it up, for the moment, these proceedings are not final. There will be developments, most likely both in the US and in the UK. And we will, of course, monitor that and report here when we have new decisions. Now, before we go into the decision of the appeal court, I think it's necessary to take a look at the first instance decision to have some context to be able to better understand what the problems were that the Court of Appeal addressed in the proceedings. And I would start with the actual front determination that the High Court did in first instance. So the court, as I said already, focused on the fundamental terms of a license. So the scope, again, this would be a worldwide license. It would cover 5G multi-standard. Definitely, there was some unclarity whether 5G would also be covered by the terms by the license that the court determined. This was clarified in the follow-up judgment in February 2024 that 5G should also be covered. And then regarding the royalties, the court basically determined a lump sum payment and said that this lump sum payment should be $5.13 million a year. And it should be this amount should be applicable both for the future, so 5 years for the future, starting with the 1st of January 2023, but also covering 6 years of past uses. So in total for 11 years, the amount, the lump sum payment was 56.43 millions. Then there was also a discussion of whether you should have also interest payments here, because of course there should have been payments in the past that were not made. Initially, the court said probably a interest rate of 5% per year would be reasonable, but in this follow-up judgment later on, it determined that the 6% interest rate per year should apply. It made, however, here a cutoff date saying that this that the interest payments should stop at the moment in which the license would enter into force, and this would be the 1st of January 2023. So this interest of 6% per year should be payable not until payment is received by Optis, but until the license would enter into force. And then there was also the discussion how to deal with the other pending proceedings, especially the US proceedings. Here, the High Court said this should stop. And in this follow-up judgment, it included a provision that the parties should seek permission by the UK court for actions that could be inconsistent with the High Court determination. And here was a big debate of whether the participation of the parties in the appeal proceedings that were pending in the US at the same time in parallel would be allowed or not, or whether permission should be sought for that or not. So this is, in summary, the front determination of the court. And I would just go also into two very important points of this decision, which were also in the focus of the appeal proceedings. There was one very decisive element in this rate determination by the High Court, and it referred to the way the court basically addressed or dealt with the expert evidence that was produced. So the parties had extensive evidence, particularly focusing on comparable licenses. There were two experts, one of each party, that tried to unpack agreements both of Optis and of Apple, and determine a rate for Optis portfolio based on this information. There was a lot of discussion in the first instance before the High Court about this evidence, but at the end, the High Court decided not to accept this evidence, to reject the evidence. And it had basically two concerns there. It found that the unpacking as an exercise was not reliable generally here, because there were three elements particularly which were subjective, and the court did not believe that they could be resolved, because we had licenses with different rate types. There were some licenses with lump sum payments. There are others on dollar per unit basis. There were some of them with an ad valorem rate, meaning that it was a rate expressed as a percentage of the price of the selling price of the products. There were cross-licensing elements which were hard to unpack, or past releases. So which part of the lump sum referred to the past, which part referred to the future. So all of these things, in the eyes of the High Court in the first instance, made all of this unpacking exercise not reliable. And then the second aspect was that the court found that the experts did not use independent judgment, but unpacked the licenses based on their clients' instructions. So the court found that this meant that they were outside of the zone of their proper expertise. The rejection of the evidence produced by the parties in the proceedings had as a consequence that the court applied a methodology for making the front determination, which was unique. And it was the methodology which was also very much in the focus of the appeal proceedings. So the approach had of the High Court had two elements. So the first one was, let's say, the description of the exercise. Here, the High Court said what the valuation should do was to determine a lump sum rate specific to Apple. So this was the exercise that the court assumed here. And given that, we will see that the focus was placed on comparable agreements actually entered into by Apple and not comparable agreements in which Optis had signed. So in a nutshell, what the court did here was to consider 20 lump sum agreements, 19 of which were agreements which Apple had signed. There was only one agreement which Optis had signed, and it was a license with Google. So the court took these 20 agreements, and what it did was to calculate basically for each license what would be the total stack price for 100% of the patents based on the rates and the shares that each licensor had. So it did that. For each of these 20 licenses, it calculated a total stack price. And then, and this was the main point which was criticized by Optis and also by the Court of Appeal, it took a simple average of this implied total stack price. And with this simple average, it adjusted that to take account of past releases. So it made a 50-50 split between past and future sales. And then it applied Optis' share of the overall stack to this amount and reached then an annual royalty amount that would be payable for Optis. And this annual amount, as we saw, was multiplied by 11. So this was, in a nutshell, the way the court made the valuation. Again, this was an approach which the court, in a sense, applied for the first time here, which was also based a lot on the fact that the evidence of the experts was dismissed. Now, a crucial point in this approach, and this is the last element here that we want, that we should discuss from this decision, was the focus on the Apple licenses, so the licenses of the implementer here. The court, the High Court, found some issues with using the licenses of Apple. For example, it found that the licensing framework of Apple includes some indefensible elements, for example, the use of the SSPPU doctrine or the demand to have a patent by patent licensing. And it also noticed that when it did this exercise to see how much each license would cost for the entire stack, that the licenses of Apple implied a considerable range of values, which was, of course, interesting because at the end of the day, it was referring to the same set of patents, so the same stack of patents. And this considerable range of values undermined, in a sense, the confidence in the figures. But nevertheless, the court accepted that the Apple licenses should be used because it found that although there were some issues, the licenses that Apple had signed were not including royalties that were pressed downwards by illegitimate holdout. So this was an argument of Optis saying you should not use the Apple licenses because they're not representative, they're not front, because holdout is involved there. And the court found that this is not the case by making a distinction, and this is something which the Court of Appeal very much criticized, as we're going to see in a moment. It made a distinction between legitimate and illegitimate hold-up and hold-out. The main idea was to say here that in every negotiation there is a degree of hold-up and hold-up, and this is inevitable. So it doesn't really matter if this happens. It does not render a license not comparable. But This will happen only if you, let's say, have crossed the line to illegitimate holdout, which is, of course, not very clear when this will take place. But in any case, the court found that Apple had not done so. So it had not engaged in illegitimate holdouts. So this meant that the licenses of Apple can basically be used. So again, this is an issue which was also very much part of the decision of the Court of Appeal, as we're going to see in a moment. Now let's turn to the decision of the Court of Appeal, and let's see what the court said regarding some of the aspects we've discussed already. So one fundamental question here, which the Court of Appeal asked itself, was whether the High Court was right to reject the evidence of both parties' experts. Again, this is a key point because by rejecting the evidence of the experts, the court then applied a methodology which was unique, so that the Court of Appeal started its analysis by asking itself, was it correct, basically, to do that and to reject the evidence that the parties' experts produced? And the answer of the Court of Appeal was clearly no here. So the court said the High Court was unfair and its critique on the involvement of the experts was unjustified because it had not really put to the experts these allegations that they are out of their zone of the expertise or that they did not have an independent judgment. So it did not really confront the expert with these allegations, but just took them for granted. And the Court of Appeal also said there was also a fundamental misunderstanding of the role of the experts. Because I mean that using a comparable approach or following the instructions of the clients was, in the eyes of the Court of Appeal, an appropriate approach in law. It had nothing problematic in this sense. Because what the experts actually did was not to do the actual valuation of Optis portfolio, but basically talk about the reliability of the data. So extract data from licenses that are already there, from comparable licenses, and help the court make the valuation itself. So that's what the Court of Appeal made clear here, that the valuation was the exercise that the court should take and was not something that the experts should have done. So the court should have also not expected from the experts to have a view whether an ad valorem rate or a dollar per unit rate was correct here, which in the eyes of the Court of Appeal both could be found. But it should have done this exercise on its own. And therefore, generally, the court found that this idea to basically leave that all aside and not consider that was already very problematic. It was, however, not only that was problematic. The court looked at the valuation approach of the High Court and found that this was flawed as well. And here there were several problems that the Court of Appeal identified. I think it started from a more principal question of whether it is true that the valuation exercise should, in the present case here, focus on determining the rate for Apple. And the Court of Appeal said this is not what the valuation is about. It's not concerned with a particular implementer, but with the value of the licensed property itself. So you can, of course, take into account the particular circumstances of each implementer that can be relevant in some respects. An example that the court mentioned here is that if you have implementers with a high selling price of products, of handsets, for example, here, then you could eventually argue that an ad valorem rate, which is a percentage of the selling price, might not be appropriate. But generally, the valuation exercise concerns the value to the implementers in general. So this was one, let's say, fundamental critique of the Court of Appeal to the way the High Court had done its valuation. The second element, which was also in the eyes of the Court of Appeal fundamentally flawed, was this simple average approach, which the High Court had done, because taking a simple average was, in the eyes of the Appeal Court, had no precedence or basis in the evidence, and it can also not be justified in principle. And the biggest concern is that an averaging exercise gives weight to all licenses as comparables, although the weight of the licenses is different. So this is fundamentally the critique that the Court of Appeal expressed here, that taking a simple average does not really give the proper weight to the individual license agreements. And this is something that the court should do in order to identify which are the best comparables to use for the valuation. Here we had, of course, a particular interesting situation that the valuation was based on licenses of the implementer. And this is something which the Court of Appeal also questioned, basically saying that if you're doing a valuation exercise, you should start the analysis from the SEP owner's licenses. These are the best place to start, but that is all it is. This is the court's words. This means that if the licenses of the patent owner are problematic, if you could consider factors like hold up and hold out, making these licenses less good, then you could also consider the licenses of the implementer, which can be useful, but in the eyes of the court, they are not the best place to start. Why? Because the licenses of the implementer include a further dimension, which is the relationship between the portfolios involved. So you have always the same licensee, but you have licensors with different portfolios, with different stack shares, but also with different portfolio quality. And here, in the eyes of the court, it's not sufficient just to say that quality of a portfolio is average without examining the other portfolios of the other patent owners. So all of this made, in the eyes of the Court of Appeal, it difficult to start the exercise or to start the valuation by using the implementer's licenses, as was the case here. Of course, as we've seen, the High Court did not consider only licenses by Apple, but also one license by Optis. This was the Optis Google license. But the court found that the way the court had done that was plainly illogical, and it found that it was a major flaw. Because what the court did here was to basically use the license of Optis as in the same way as like any other license that was considered, which all of them, however, were licenses of Apple. And the way it did that, in the eyes of the Court of Appeal, distinguishes the true relationship between the Optis Google license and the Apple licenses, which is a major difference, as given that the lump sum for the Optis Google license was based on a significantly lower number of units, which led the courts to say that if you would use the per unit rate from the Optis Google license, then and apply this to the Apple sales, then you would get a significantly higher value of the license. So here the court said problematic that the licenses of the patent owner were not the starting point of the analysis, and the way the one license of the patent owner was used was also problematic because basically it failed to make the distinguish a proper distinction with compared to the licenses of Apple, and give this license the proper weight that it should have in the analysis. So, having said that, the court moved on then to ask itself the question whether it was right, the High Court was right to take the values of the Apple licenses and use them, consider them as a whole, without any differentiation or any distinction. And the answer here was also a no. So the court found that it was not the right approach to evaluation. The Court of Appeal questioned already the assumption that the Apple licenses were proper comparables because they were not concluded under illegitimate holdout, by basically saying that this distinction between legitimate and illegitimate holdout is not really valid, but it's rather unhelpful and led the judge in the first instance proceedings into error. What was the point here that the Court of Appeal wanted to make? Well, it said if there is a degree of holdup or holdout, then the actual license is not front. Because the court said holdup and holdout are mischiefs, and the front system aims at protecting both parties, against both holdup and holdout. And what the valuation exercise should actually do is to mirror a hypothetical negotiation between a willing licensor and a willing licensee, which per definition does not include any holdup or holdout. So asking yourself in this context here whether a license should be used as a comparable or not, whether there had been unlawful or illegitimate holdout, so whether you have, let's say, crossed a line, which is also hard to define, but nevertheless, it's a question that is not really valid in the front rate setting context, because any degree of holdout would make the license not comparable, at least would make clear that the license is not front. Turning then to Apple's licenses, the court disagreed with the first instance court here and said that there is holdout involved in the Apple licenses, and the High Court had erred in considering almost all of these licenses as a whole. There were two elements here which, in the eyes of the Court of Appeal, indicated that there was holdout involved in the Apple's licenses. And the first one was the insistence on a patent-by-patent licensing. The Court of Appeal believes that this is manifestly showing that there was at least a degree of holdout involved in these licenses. But then what the court also saw as an indication of holdout was this spread of the values implied by the Apple licenses that we talked before. So if you remember, we said there were between these 19 Apple licenses that the court used here, you had a significant spread of values, although they would all basically refer to the same stack of patents. And the court said this means that either these licenses are not all equally good comparables, or that not all of these licenses or the rates agreed in these licenses are front. The court found that Apple, when it can do so, it uses its significant negotiating strength to agree lower rates than would have been agreed between a willing licensor and a willing licensee. And this was indicated by the fact that you had these differences between licenses with patent owners with largest stock shares, for example, Ericsson and the Digital and Nokia. And these licenses are by and large imply that the total stack is more valuable than licenses with smaller implementers, with smaller patent owners. So generally, the court was not convinced that using the Apple licenses as a whole, as the court have done in the first instance, was the right approach for the valuation. Now, the court said, of course, it was not the right approach. So what do we do now? Should we send the case back to the High Court to have a retrial and to start from scratch? Or would the Court of Appeal keep the case and make the front determination itself? And the Court of Appeal decided to do the second option. So it did not make a retrial, did not order a retrial. It found that it was the last resort, and in the present case, it was not needed because there was evidence collected in the first instance, maybe not exactly focusing on the aspects that were relevant now in the appeal, which was particularly the Optis Google license, for example. But on the other hand, the court found that all of these elements were part of the first instance proceedings. So it was not justified just to order a retrial where more or less some part of the evidence would be reused. And apart from that, the court also said the valuation exercise now in the appeal proceedings was greatly simplified because both parties had made several concessions regarding several points, which made generally the assessment easier because there were not so many disputes on every single aspect. For example, Optis in the appeal proceedings relied only on one license agreement, which was the Optis Google license. It did not require any more an ad valorem rate, and it did not contest also its share to the, of its portfolio on the overall stack. On the other hand, Optis had dropped the SSPPU case in the appeal proceedings. So the court thought that now it was in a position to do the determination itself and did not need to send the case back to the High Court. So what did the Court of Appeal do then? How did it make the front determination? What was different? What was different basically was that the Court of Appeal relied on the evidence that had been produced in the first instance. And it particularly relied on data which was based on a dollar per unit unpacking of licenses. So this was something that the expert had delivered, and as we said already, the High Court ignored. But this data, this was in the eyes of the Court of Appeal relevant and could be used here. So this is what the court used then. It used the existing data where the expert had unpacked the comparable agreements on the dollar per unit basis. This was the first step. Then what the court did was to calculate the rate which every given license would imply for Optis's share, which was considered to be 0.38% of the total stack of relevant SCPs. And then looked at what is the implied dollar per unit rate coming out of these agreements for Optis. And then it took a look both at the Google Optis license, which was a license of the patent owner that the patent owner had signed here, and licenses that Apple had signed, but it did not take every license that Apple had signed into account, but considered only the 4 Apple licenses with the highest implied dollar per unit rate for Optis. And the question is now, where should you actually locate the Optis rate? You have 2 different sets of comparables here, and you need to make a determination. So which ones choose, or if you don't choose neither, where should you locate the Optis rate? Generally, what the court said here, if there is a range of front rates, the patent owner is entitled to the top of that range. But again, what would be the right approach here? Would it be the right approach to use the dollar per unit rate implied by the Optis Google license? So was this the right comparable, and was this the right price for the Optis portfolio? The court found that it was not the case. It found that this rate implied by the Optis Google license was too high. And to basically confirm that, it made also a so-called top-down cross-check here. It said that if you would apply this rate of 27 cents per unit on a Google phone, this would mean that the total stack that Google needed to pay for its phones would be 15% of the average selling price, and this was, in the eyes of the court, too high. So this rate was too high. Then the question was, what are the rates of the 4 April license coming from the 4 April licenses? Are they good enough? Can you go lower than these rates, as the High Court had done? The Court of Appeal found that the rate that Optis is entitled to should at least be as high as the rate implied by the 4 April licenses. So it should not go below. The court found that there is no justification for going below. So this should be basically the least that the Optis should get for its portfolio. So what the court did at the end was to go somewhere in the middle and determined that the dollar per unit rate for Optis should be 15 cents per device, which is between the higher rate of the Optis Google license and the lower implied rates from the 4 April licenses. The court said here, of course, the licensors are not similarly situated here, but it nevertheless found that the data was sufficiently reliable, and it did, again, a cross-check by saying if we use this 15 cents per device rate and apply this to the 100% royalty stack, if we look at Google phones, it would have a total royalty burden of 8.4%, which was considered to be fine. If we apply this to the Apple phones, which had a higher price, average selling price, this would be between 3.9 and 6.3%, which was also fine. So this was then the rate which the court found to be front and reasonable for Optis. Now, if we look at that here, this is actually the blue box, so the 15 cents, which is between the rates coming from the Optis Google license and the rates coming from the Apple licenses. And what the court did then was to multiply this amount with the annual sales of Apple, applying a 10% discount on the projected future sales, and came up with a lump sum payment of $502 million for the period 2013 to 2027. So this is, of course, if we compare it with the first instance decision, a considerably higher amount. Here, if we would like to see where the High Court was, it is this red line where the dollar per unit rate that the High Court had determined was between either 0.01 cent or 0.02 cent. So the difference here at the end of the day was significant. The Court of Appeal determined a lump sum for a license to Optis portfolio, which was very, very much higher than the High Court's decision. So to compare, the first one was around 54 million US dollars, and here we had a lump sum of 502 million US dollars. So this was a very big difference here, considering the amount of the rate for Optis. We had, however, a second element which also might have a significant difference in the total amount that would be payable under the license. And this refers to the interest payment. Because here, as I said already, we had also an interest for payment for past sales. The court determined an interest rate of 6%, but said that this rate should stop when the license would enter into force, which was the 1st of January 2023. Optis was not satisfied by that, and it said, well, if you have an interest rate for the past, it should basically apply until there is an actual payment, which is, I think, the common way these interest rates are calculated outside of our context here. And the Court of Appeal agreed with that. So it found that it was not correct to have an interest stop day at the day in which the license should enter into force, but that interest should be paid to Optis until actual payment is done. And this means that this amount will also be higher compared to the decision of the High Court, because the years in which for which interest is going to be owed are going to be more than, of course, the 1st of January 2023. We are already 2 years after this, almost 3 years after this moment in time. So here, this decision regarding the interest will very likely lead also to a higher amount that Optis is entitled to. Now, the last 2 points here is what I mentioned also in the beginning, how to deal here with the US proceedings. And it was a very specific question here because, as we said already, in the US, we had already a judgment for damages before we had even the first instance rate determination in the UK. So a lot of discussion arose around this topic, how to deal with that, because the determination in the UK was for a global license. And theoretically, this would include also the US patents, which had been adjudicated in the US and had led to this $300 million damage award. So how to deal with that? Should this be on top of the amount that has been determined in the UK? Should this be extracted from this amount? So how to deal with that? The decision of the court here was very pragmatic in a sense that the court said this amount payable based on the US awards, it should be the floor for the royalties payable by Apple under the license that will be determined by the UK courts. And why is that? The main reason why the court decided that this is proper here is because it saw that it was Apple's fault that the proceedings in the US went so far as to have an award and to have a final judgment. And this is where what I mentioned in the very beginning when we were talking about the story of the case plays a role, because the court said, although the proceedings started simultaneously and it was clear that there could be some overlap, Apple refused to accept the court determination in the UK until the first judgment on the front injunction was delivered in September 2021. This was almost 2.5 years after the proceeding started. And not only that, it had appealed against this decision and had basically kept its options open until it withdrew the appeal against the front injunction judgment before the Supreme Court in September 2023. So considering that, the court saw that it was not unreasonable for Optis to keep the proceedings in the US alive and to seek for damages there, because again, until September 2023, it was not clear that Apple would accept the UK court determination. On the contrary, the court also found that Apple had not been very fair in the way it asked Optis to deal with the proceedings in the US. So what Apple had suggested basically was to consent that the US judgment would be set aside. And the court said that a willing licensee in Apple's position would not have done that. Finally, also committee played a role here by saying that the US damage awards should be taken into account. because the court said that English court should not interfere with judgment that have been delivered and regularly obtained from a competent US court, especially since no compelling reason for doing that were presented here. So at the end of the day, this issue of comity and also Apple's behavior led the court here to say that the result of the US proceedings should be taken into account. It cannot be ignored, and it will be taken into account in form of a floor for the royalties that the UK, the court-determined license is going to fix. And this was the solution for this discussion here. Finally, the last point, it referred again to the relationship between the US and the UK proceedings. And what was contested particularly here was the order we discussed also in the beginning of the UK High Court regarding requesting from the parties to seek permission for acting in other proceedings, including eventually for acting in the US proceedings. So the question was it appropriate to make this order here? And the Court of Appeal found that the High Court was not correct in doing so. This provision was seen as not justified and unnecessary, and also unclear because it was not clear whether it, for example, included the pleadings of Optis or acting in the pending US appeal proceedings. It was unclear. But at the end of the day, also looking maybe at comity again here as a factor, the court said that this provision constitutes an inappropriate regime of court supervision, and it should also not it should have not been granted in this form. So again, in line with what the court had said regarding the damage awards here, this intervention with blocking or hindering the parties to have proceedings in parallel was very much seen very critically by the Court of Appeal.